This conference will now be recorded.
All right, it is February 23rd, 2022, and it's cold outside today. I know driving in it was like 8 degrees, but it's bright and sunny, and that snow we received is very, very welcome. We are definitely in need of more moisture this winter. I hope we get some more. We do need a good snowpack. I'm just hoping we get a lot of snow. Keep the snow in the mountains. I can handle rain down here. I think we all are kind of feeling that same way. Though it sure is nice to see some fresh snow. In the meantime, today's topic of our meeting today is going to be going over some forms that you guys may not be aware of. Some of these are newer forms. Also want to talk about some risk management tools that we can all utilize, and some places to go to find some great resources. So with that in mind, let's go ahead and get going with starting right away with our forms. And so you guys may not be aware that there are some of these forms in here which I think are very pertinent and very helpful. So these are some new forms connected with OREF, in which we have a new advisory to the buyer, which is called waiving contingencies. Now, when we're representing a buyer, we never want to waive contingencies at all, unless that's the only way we can actually get and win the deal. And I think it's really important that we're aware that this advisory is in effect. This is an advisory talks about specific terms and conditions to protect and inform you as you go through the process of purchasing a property. Why do we have an inspection contingency? Why do we have a disclosure contingency and a title contingency, appraisal and financing contingencies, all these sort of things? Again, we all know from a buyer's perspective, these are things that help protect the buyer when they go towards purchasing property. However, in multiple offer situations, we're often finding that in order to win the multiple offer, our buyers need to start considering waiving some of these contingencies. If they are electing to do that, this advisory is really, really helpful. It also it protects us, because here's this line here: by signing below, you acknowledge that your agent has advised you not to waive any of the conditions included in the real estate agreement. If you do so, you're assuming all responsibility for loss of earnest deposit if the land improvements or transaction terms do not meet your expectations. So here is the reason why we have those contingencies. Here is where the buyer can elect to waive it, and with having this verbiage in here, it also helps protect us as buyers' representatives. So any questions on this advisory? Anyone have concerns about it? I think it's just a great one to pull out and let them know. Again, risk management. Okay, if no questions on that, I'm going to go on to the next one. This is a one, it's a newer one about advising the buyer recording devices may be present. This is really true in this time of a lot of smart homes, also with people maybe putting hidden microphones and various other things. People need to recognize that when you're in a home and you're talking about it and maybe negotiating the purchase of the property, the seller might be hearing what you're saying. And in fact, I've heard some feedback from people in which they said, my seller was really ticked to hear what these buyers were saying, and they would not sell to these buyers, even though the buyers may have offered them a really good price. So if you are working with a buyer, just be aware that this advisory to buyer recording devices may be present could be a great tool that you could use when you start showing property to them. We may say it, but this is also a way of getting it in writing. So again, it's only signed by the buyer, as is this one about the waiving of contingencies, only signed by the buyer. So these are some tools working with buyers. Okay, the next one I'd like to go over is the advisory regarding smoke and carbon monoxide alarms. We had this advisory in the past and they've pulled it multiple times. The reason why is the fire codes, the links to the fire marshal, Oregon statutes are always changing. And so when you produce an advisory that may be changing over time, it's not necessarily the best tool. That's why now this advisory, again, it's signed by both buyer and seller, has hyperlinks in it. And so keeping it as a PDF that has live hyperlinks is very helpful. People can use this. They can click on the multifamily Northwest link. By the way, if you're ever dealing with tenant properties and things like that, multifamily Northwest is a great resource. Also links to the Oregon Construction Contractors Board, the Oregon Building Code, Oregon Fire Code. All these hyperlinks are extremely helpful. And again, this advisory is a new one, and you can incorporate that into your contracts. If you need to add additional resources, sometimes people might be looking at other resources for some of these things too. You can always just add one in here too, along with a website. But these again are live hyperlinks, and then we'll go directly to these sources so people can read it for themselves. Again, we are not the experts. We just know how to point people to the direction of the experts in these specific laws. So again, this can be signed by both buyer and seller. Now, here's one in which the buyer's notice to seller of revocation and demand for refund. Now, this is used when the buyer is terminating based upon the seller's property disclosure statement. Remember, there is built into the purchase agreement and also in the property disclosure statement a 5 business days of revocation based upon the property disclosure statement. This is this form is used if you are terminating based upon this. So it has to be within 5 days of receipt. And remember, the receipt starts upon receiving it by the buyer's agent. Pulling it off of MLS does not constitute delivery of the disclosure statement by the seller. The listing agent actually needs to send the form directly to the buyer's agent. And once the buyer's agent receives that, that starts the clock for the 5 days to terminate. So even if your seller or your buyer signs it on day 1 of receiving it, they still have 5 days to terminate based upon receiving the disclosure. So even if your client has signed it and you've sent it back to the listing agent, the clock is still going on those 5 days of revocation. So say in review of the disclosure statement, the buyer finds something that they don't like. They have the right to revoke the contract and to terminate without seller's signature. This is one of the revocations that is done that does not require the seller to agree. So you would take this document, you would send it to whoever's holding the earnest money. In this case, in almost all cases for us, is escrow. Then escrow does not have to get seller's signature. They are required by statute to return the earnest money to the buyer. So you would check this box here. Either the seller's property disclosure statement was delivered to the buyer on whatever day the buyer's agent received it, or that the property disclosure statement was never delivered to the buyer. So again, when this comes, you click one of these 2 boxes, and then you must deliver this to the seller within the 5 business days after the date of delivery of the seller's property disclosure statement, or any time prior to closing if the property disclosure statement was never delivered to the buyer. Now recognize that the property disclosure statement is only required on owner-occupied property. If you are selling or representing a buyer in the purchase of multifamily property, it's not required. The law does not require a property disclosure statement in those sort of situations. But in the case of a owner-occupied property, yes, the right to revoke and terminate the contract based upon disclosures is one of those things that's unilateral to the buyer. Any questions on this one or any of the other ones I've already gone over?
Yeah, Linnea, does that apply to a single-family residence that's a rental home and the owner does not live in it?
Yes, it does. Actually, it does. So, in fact, we are representing one of those right now in which the seller has rented the property and, they do not have to provide a property disclosure statement on that. In the case of our seller, they didn't know anything about the property outside the fact that they own the property. They've been hiring an outside management company to take care of it. But yes, the disclosure statement is only required for buyer occupied or seller occupied property. And that's clearly, that's written in the statutes. So, but however, that does not change the fact that the seller needs to pass on information to the buyer about anything they know about the property that might be pertinent. So the fact that they had the roof leak last winter still needs to be passed on. And in some cases, the best way of doing that is through use of the property disclosure statement. But again, that does not change the fact it's not required in rental property. Does that answer that, Gary?
Yes, it does. Thank you very much.
Great, great.
And I have
any
a
other
quick question. Yeah, you briefly mentioned escrow. So on this form, do you still have to fill out that escrow form to get the earnest money back?
Actually, you don't, but the escrow company may require it.
Okay,
This form by itself said, look, they would probably have their own forms, but we're talking about the termination form in which we're dictating how earnest money is dispersed. This form by itself should be sufficient for escrow. There's been a couple of times in which, before we even had this form, I can recall of one time in which we had a buyer terminating based upon disclosure statement, sent notice to escrow, and escrow said, well, you have to have seller sign off on it. And we were like, no, that's not the case. And they then consulted with their legal counsel within the escrow company, and they said, yes, you're right. We don't have to have the other side sign off on it. So again, that's statute. Any other further questions on this?
Yes, Linnea, do they still need to do the seller, if it's like an investment rental house, do they still need to do the disclosure and just do the first section where they waive it, or do they just not have to do it at all?
They don't have to do it at all.
Okay.
I ran this by attorney several years ago when this first popped up, and yeah, it was one of those, we kind of always made assumptions that you always have to disclose, and it's not required in rental property. It just isn't. Now, the first page of the disclosure statement, where you're exempt from it, the exemptions are first sale of new construction, but the seller is supposed to write in what the permit number is for the sale, how the house was built, or if they're using the new construction purchase agreement, there's a section there where the seller can disclose the permit number of how the home was built. That's an exemption. The sale of REO property is an exemption. The sale by a government entity is an exemption. And then also the sale of a executor or trustee who is working on behalf of an executor. So sometimes people get confused with the idea of trustee, in which the home is owned by a family trust. That's not the type of trustee we're talking about. We're talking about an appointee by the court to handle the sale of an estate. So again, that's the property disclosure statement, the exemptions. But in the case of the sale of rental property, multifamily, duplexes, all that stuff, it's not required. It just isn't. The law does not require that. But again, it does not say that the seller is not obligated to say and pass on the information that they know, which they are. Just as true with the sale of vacant land. The vacant land disclosure statement that we have is not required by state statute. It's just a handy way of passing information on about the property. And so in a lot of cases, people are using the seller's property disclosure statement on selling multifamily property just because it's a great way to pass this information on, but it's not required by statute.
Yeah.
Any
Beautiful.
further questions on that?
Yeah, perfect.
Great. Further questions on that? Great. I know I kind of skipped over these other ones real quick here, the advisory on smoke alarms, and this first one about recording devices, and this first one also about waiving contingencies. So for those who came late, you may want to listen to that recording on these things first. Okay, now the next one I just wanted to go over is the waiver of the right to revoke. There was some confusion we had in a deal a couple of weeks ago in that the buyer that we did not represent we represented the seller in the scenario, was terminating based upon disclosures, but they gave us this document. This is the wrong document. This is the waiving of the right to revoke based upon the property disclosure statement. The only time you would ever have your buyer sign this would be one of those scenarios in which they're trying to win a multifamily or a multi-offer situation, and they want to show that I'm waiving the right to revoke based upon the property disclosure statements. So, and again, we take all these contingencies of waiving the right for a buyer to terminate very seriously, and that's why we would use that first advisory, because we want to protect ourselves. We're never advising our buyers to give up any rights that they have, but if they have to, in order to win a multifamily multi-offer scenario, sometimes they may want to use this form, and this is again waiving the right to revoke based upon the seller's property disclosure statement. So that's what this form would be used. Okay, any questions on this one? Okay, if not, let's go on to this next one here. This is the buyer's representation agreement, and we used to call it the buyer's contract. I always encourage our clients to sign one of these when you're working with buyers. If you're working with buyers, I know it's one of those documents that a lot of people don't like to throw out there because they say, well, if my buyer doesn't like working with me, they should have the right to work with someone else. But then I hear these stories of our brokers who have worked with clients, with their buyers for 6 months. They've shown them 50 homes, and then they hear through the grapevine that they ended up writing an offer to purchase a model home or a home that is listed with someone else just because they happened to walk into an open house and they were given a high pressure sales tactic. This particular document will protect them, will protect not only our broker, but also our buyer, in that if they're writing with the listing agent, maybe they feel that they're not getting full representation because of the listing agent has a split fiduciary duty. I know that our listing agents within our brokerage know how to handle both sides of a transaction, but some of them just don't want to do it. They would rather represent one or the other. But again, the buyer's contract, it's not used as often as I wish it would be. In some states, for instance, in Utah, it's required. So if you're starting to work with a buyer, you have your buyer sign a buyer's contract. It protects the buyer, it protects you as an agent working with them. Basically what this contract says is if you're going to write a contract on any property, you'll be working with me. Again, you fill out the blanks on it. So we appoint the buyer's broker and our firm to assist the client in locating and negotiating for the purchase, lease, option to purchase, or exchange of property described below. And so here you write the term in about when you will start it and when it's going to terminate. There's also these boxes here that you can check if you wish, that either party can terminate this agreement with written notice to the other party without further obligations, or if client terminates this agreement, client shall pay broker an early termination fee as follows for all expenditures incurred by broker. This is negotiable. The way I've had brokers successfully use this contract is when they start working with a buyer, they pull out the buyer's, the pamphlet, which we all are required by state law to use. And they explain the idea of agency, what is a buyer's agent, what's a seller's agent, what is a limited agent, how does it all function, how can you work on both sides of a transaction, how that all works. Then they say, after they've provided them with the pamphlet, they say, here's another document that we use in Oregon. It's called a buyer's representation agreement. And it basically says that if you do buy and you're not obligated to buy, you will be using me. And that's basically a way to protect you from high pressure techniques that might happen when you go out there to an open house. And it also protects me because I will be spending a lot of time finding property that may work for you, doing previews, maybe even doing Skype or tours through the property, talking to listing agents, setting up all the stuff, and then of course negotiating a transaction. I might be spending 10, 20, 30, 40 hours and recognize that I don't get paid until we actually have a closing. And so this protects me from my time working on your behalf. And so that way you will be, you know, my time will be reimbursed at the point in time when we have a closing. Then sometimes people say, well, what if I decide I don't want to work with you? The way our buyer's agents have really successfully overcome that objection is by saying, okay, what I'm going to do is we'll work together for one afternoon. I'm going to be showing you property on this day. And if we decide after that day of working together, either one of us decide this is not a good fit. You don't like me, I don't like you. It goes both directions. We can just take this term and terminate this, tear it apart. You're obligated. You can go off on your own way. I will go off on my own way, and I will not be spending any more time working on your behalf. And then you'll be free to work with someone else. At that point in time, the buyer is usually saying, well, that makes sense. And usually after working with our broker for an afternoon, they're saying, yeah, this is working out really well. You really listened to me when I explained to you the kind of property I was interested in. And you are showing me property I think that would really work for me. And so I really appreciate your efforts in screening and finding property that will work. And usually it's a great fit. And then it also protects us in when that buyer is out on their own and they walk into that open house and that high pressure listing agent or that high pressure agent who's working the open house says, well, if you want this house, you better write it right now with me. Then that buyer will have the protection saying, I really am interested in this home, but I have a buyer's contract and I have to call my broker because you know that they need to be working with, I'm under an obligation to work with this buyer's contract. And then that listing agent or that agent who's manning the open house will back off. So any questions on how this works? Because it's been very effective.
Yeah, those boxes in number 3, Linnea,
Uh-huh.
you can put down, you know, a termination date, but then you're probably going to get asked, well, which box are we checking?
Well, you don't have to check either one. You can check, or you can check only one. So either party can terminate with written notice to the other party without further obligations. Or if client terminates his agreement, client shall pay broker an early termination fee as follows for all expenditures. The way they changed this form this year, I don't like it. I don't like the fact that they're giving people an out without reimbursing the broker. I don't like that. I really don't. But it's the way they fill out this form right now. It says check only one. You can also not check either one. The other thing that's really helpful about this is the compensation. So when you're filling in the compensation, most people will say that commission is what's ever offered in MLS. We are seeing more and more the co-op commission offered in MLS being reduced. We know we've seen Polish and Hayden now offering a 2% co-op commission rather than at least 2.5%. You can negotiate with your buyer that they are going to pay a 2.5% or even a 3% of the purchase price here. And then you would explain to them that the seller is advertising in MLS what kind of commission they will be offering to the buyer's agent. And if that co-op commission is the same as what we negotiate here, you will not be paying anything extra, buyer. But if it's less than that, you will be paying the difference. And the first time I actually saw this, because I do check when we get a closing check that the commission that we're paid is what was advertised in MLS when we're representing a buyer. And we got to check. Sometimes they come in, almost always they come in less. I mean, if there's any discrepancy, it's less than what was the advertised commission. That's usually having to do with maybe a seller credit or a time in which there's a repair and the brokers then cover the cost of the repair. I can usually find it in the contract somewhere. But one time I can remember the first time we had the commission come in that was higher than was advertised in MLS, and I called up our broker. I said, this is wrong. Why was it higher? And then they reminded me about the buyer's representation agreement in which they had negotiated a 3% commission, and the buyer ended up paying the difference between those two. And so that was a really nice thing. And so in this world of I guess the word of changing real estate, in which the co-op commission is fluctuating, you can get your buyer pinpointed on a specific commission that you would be expecting by utilizing this contract. Again, I would say probably 90% of the time I see this filled out, it's filled out with whatever's advertised in MLS. So again, you can do a non-refundable fee or any additional provisions. This is where they would usually write in commission to be whatever is advertised in MLS. So, but any questions on how that part of the contract can work as well? Okay. All right, if there's no questions on that, let me move on to the next one. So this is the investment property addendum. So when you're representing a buyer in an investment property or even a duplex or a rental property, you can use this form. It's a helpful tool in which you're asking as part of your offer, when you're actually offering on it initially, that this is all going to be part of due diligence items. And we want the seller to provide the following documents, rent rolls, delinquency reports, accounting of prepaid rents, any sort of financial information such as the last 3 Schedule E's or 1040 or comparable business schedule returns of entity owner, all these sort of things that would be helpful if you're representing a buyer in investment property in which you want to make sure that this is actually a good investment and that everything that is advertised as far as the, that they were going to provide you with documents. These are the specific documents that your client actually wants. Helpful stuff, even things such as floor plans, as-built plans, if they have it, latest appraisal, engineering reports. So this goes for not only small investment properties, but it could also be for very large investment properties. Good tool. Along the same line, I'm going to skip this here and go to this one, is the tenant estoppel certificate. I don't know if you have ever dealt with something like this, but this is also involved in investment property in which you have records from the seller that they provide you with that says this is what the rent is. Well, this is a way of going to the tenant themselves. And here's the buyer and the seller, and whereas the landlord and the buyer have entered into a real estate contract to purchase this property. Now the undersigned tenant acknowledging this certificate will be relied upon buyer and its lender connection to state the following, that the lease attached is true, accurate, and a complete copy of the lease. In other words, we're going to the tenant themselves to verify that the information provided us by the landlord is accurate. And it's a good tool to use if you have any questions on whether or not the seller is being truthful. Again, it's signed by the tenant. Okay. This document, now we have people use this one quite a bit, and this is the buyer's unconditional disapproval of the home inspection. And this is termination based upon inspections. And recognize that we have the home inspection, but we also have inspections on other things as well that have their own timelines. So the home inspection, the templated figure there is you have 10 business days after ratification to perform all home inspections and negotiate repairs. So 10 business days to do that. If during that point in time, the buyer is unhappy with the condition of the home based upon the home inspection, this document would be used to terminate. But you also have timelines connected with the septic system and the well. They have their own timelines, and recognize you can still terminate even after you've negotiated everything with the home inspection, and you can terminate based upon the septic and the well. So, but this is the document that's used to terminate based upon disapproval of the property based upon one or more buyer's inspection reports, and they are terminating. And again, the right to terminate is unconditional on the buyer. They have the right to terminate this. Just like I said at the very beginning, unless they've waived Any contingencies here? And again, this advisory for people who came in late is a helpful advisory if you have a client who's thinking of waiving their contingencies. Any questions on this document? Because it is used. We are seeing this often used. The seller's fee agreement is, yeah.
Quick question. Oftentimes I'll put into an offer that the home inspection is for informational purposes only, as a way to kind of softly waive an inspection contingency. Does that also negate our right to unconditionally disapprove with that wording in the offer?
It could. It's one of those kind of, depending upon what side you're following on, when people are using that phrase in there, the other side can say, well, you're waiving your home inspection contingency. So unless it's clearly stated in that phrase that you're still retaining your right to terminate based upon home inspection. What I'm seeing a lot of people do that in which they're softening all that, Eric, is they're writing in that buyer is doing a home inspection and will only negotiate repairs that exceed a certain figure. So for instance, they're willing to accept the home if the repairs needed are less than $5,000 or less than, I even saw one the other day that was less than $10,000. They only want to negotiate anything over $10,000 in repairs. And I've also seen people using the same phrase you're talking about, that they're retaining the right. It's just for informational purposes. And yet and they're also using a phrase that they will not terminate based upon home inspection. If they're using that phrase, it's very true. They are not going to terminate based upon a home inspection, but then they're going to now know what the house needs. And so if they find out the house needs a whole new roof and the foundation is shot and there's some major issues with mold, they are taking on that house. So I think maybe a better way of phrasing that would be that they're doing the home inspection for informational purposes for any repairs that are less than $5,000. Anything over $5,000, they're retaining the right to terminate and or negotiate repairs with the seller.
Perfect. Thank you.
Yeah. Any other questions? Yeah.
Yeah.
Diane?
Can you confirm, does it still remain that you don't have to give a reason? You can just state based on the home inspection? That's not
the home inspection. Yeah, the home inspection does not require a reason. There's nothing in here that says any reason why. But of course, the seller then has the right to ask for a copy of the home inspection, and they'll find out. But the right to terminate based upon home inspection is unconditional, and they can just say it's an out. You know, the buyer at that point will have put out money for the home inspection, but they just decided for whatever reason they don't want to move forward on this purchase, and they can use this as an out. And so, yeah, there doesn't have to be any reason whatsoever. In fact, we've had times in which that's done. Our seller looks for asks for a copy of the home inspection. They're given it, and then they see there's nothing here, and now they post it to MLS, and they can say, here we go, recent home inspection, and then a new buyer pops in and says, I'll take that home inspection that was done for the previous buyer, and I see there's no issues with the house. I'm waiving my home inspection. There you go, Eric. They're waiving their home inspection, their right to terminate, because they feel pretty confident moving forward on the home. Any other questions on that? Okay, if not, the seller fee agreement. This is a great tool to utilize when you are representing a buyer on a FSBO. And this is a tool that is used to let the seller know that there's no agency relationship. Seller and agent agree. Agent is not and will not act as the seller's agent or otherwise act on seller's behalf in regards to anything in there. You have no representation, seller. However, I'm representing a buyer, and if we do close on this property, you're going to pay me this amount of money that we negotiate. And so it's a protection to make sure you get paid when you close on this. It also enables the the seller to know that you're not representing them. It's a great risk management tool, especially if you combine it with this other document here called the unrepresented party acknowledgement. This is another document that I don't think people are aware of. It's basically saying that the unrepresented parties acknowledge that the agent is representing only, say, the buyer. The agent does not represent the unrepresented parties. The amount of compensation, that's negotiated in the fee agreement. And understand the agent is going to comply with the duties agent has to represent to the unrepresented parties under Oregon law, which are, we always must deal honestly with the other side, represent all written offers, written notices, other written communication to and from the parties in a timely manner, and no other duties to the other side. Because agent has a duty to disclose material information to agent's own clients, the unrepresented party should not disclose any confidential information to the agent, basically letting them know that if the seller tells you, well, something that, and you're not representing the seller, you have no obligation to keep that private. So you're letting them know if they want to tell you something, it's going to go to the other side. It also says that the unrepresented party has received initial agency disclosure pamphlet. So again, this is another risk management tool. And we've always told people if they're not being represented by us, that they should consult with their own legal counsel if they have questions on anything. Any questions on the use of this tool, this document here? Because again, these are documents that I don't think a lot of people know about. They are helpful given certain situations. If there's no questions on that, I want to go to two other documents which I think are super, super helpful. I have a couple brokers who are using these on with every client. This is called the Oregon Property Buyer Advisory. And when I'm seeing people waiving contingencies, buyers are waiving certain things like waiving the right to do a home inspection, I'm asking this to be signed. This is a great tool that is produced by the Oregon Realtors. And what's so nice about it, it is another risk management tool. It's 23 pages long, but it has hyperlinks. So for instance, why a professional home inspection? And that's the first thing they talk about. It's here for people's protection. It has a website, links here, standards that home inspections must abide by, consumer protection notice, all these sort of things. These are tools, talks about pest and dry rot. Again, it has so many different, let me just scroll through it really quick here, repairs and remodels, Home Buyer Protection Act, about radon, sewer and septic systems. I have some of our brokers are using this for everything. What about an underground oil storage tanks? Environmental hazards, what are those things about? Again, we are realtors. We fill in the blanks, we represent clients, we negotiate things, but we're not experts on wood stoves. Here is a tool that can help explain what wood stoves are all about. How about mold? Tell me about what's wrong with mold, or smoke alarms, all the stuff. And at the very end of this advisory, it has for additional information who to connect with, and then here's a place for your buyer to sign. I'm asking for people when we have waivers of contingencies, just to make sure we have protection for ourselves in here. It's not only this document, but the other one is the one for sellers. And these are updated. This one's from 2019, the one for buyers is from 2020, and they do get updated periodically, and the hyperlinks are made to work. So just recognize that these are great tools that you can provide to your buyers and to your sellers at the point of time when you take a listing for the seller, and again, wonderful tools and hyperlinks for your clients. What is a listing agreement? What's an MLS? What are seller costs and expenses, taxes and tax withholding on real property conveyances? People sometimes are questioning about what's going on. I've moved out of state. They're holding taxes back from me. Why is that? And again, this is the link. It explains what it's all about. So great tools. Any questions on these? Okay, if not, then I'm going to go to my last document that last thing I really want to go through. Another great tool is the Oregon Realtors. This is the Oregon Realtors website, our state association. And I have clicked, you go to the main website, the main area, here's the home page, and you scroll across here to risk management, and you click on risk management. There's a whole slew of stuff down here, all these different tools that you can, here's where you find the buyer and seller advisory, and I will send you hard copies of those as well. Information on the Code of Ethics guidelines, risk management toolkit. Now that toolkit I know is going through being revamped. It's hundreds of pages long, and I know that Oregon attorney and an assistant are going through it just to make sure it's up to date as much as possible. But things here on the left are some of the most pertinent stuff that we're dealing with right now. For instance, the new law that went into effect in January is the love letter law guidance. What can we and can we not say regarding love letters? We know this is a new law that is requiring sellers agents to reject buyer love letters, photographs, and similar communications. It's a new requirement to the statutory duties of a seller's agent. And again, it's in order to help a seller avoid selecting a buyer based on fair housing issues. So what can we actually legally say? Here's some tips. So establish with your client at the time of listing that you will be rejecting any non-customary documents that come from the buyer or buyer's agent. This way your seller will not be surprised. Discuss with your seller what's customary and non-customary based upon the guidance from the Oregon Real Estate Agency. Because seller's agent cannot accept them, buyer's agent should also establish with their clients at the beginning of the agency relationship that the buyer's agent will not be sending love letters. If the buyer understands that by law the seller's agent must reject them, there's no point for the buyer's agent to send them to the seller's agent. So what can we actually legally do? You can provide information to the seller on the qualifications of your buyer. So you can pass on information that your buyers, say your buyers are just they're doctors starting new jobs at St. Charles, and they love your home. There's no violation of fair housing with that. You can also say here's their attached pre-qualification letter, and they're putting $300,000 down. They are fully qualified, ready to move forward. Those sort of information are allowed. That's not a violation of fair housing. But you know, those are things, and the tools that we have here in the Oregon Realtors, they're going to give us a lot of help on making sure we're doing things right. I have to talk about this one here too. There are new advertising rules that went into effect here January 1st. So this, again, you can hyperlink to the actual Oregon Administrative Rules chapter. So what's happened? Here's a big one. Principal brokers no longer need to approve the advertising of their associated brokers. Brokers are now legally responsible for their own advertising. Of course, firms may still choose to have their own office policies related to advertising approval. So in our case here, guys, I love to review your advertising. I sometimes find typos. I sometimes find things that I think are better phrased a different way. Sometimes I locate things that may be in violation of Oregon requirements, and I'm happy to continue on, but it says I no longer have to. So there you go on that. Also, we no longer have to say licensed in the state of Oregon on online advertising. That's a new one. Also, you no longer need to have your name and registered business name on each social media post that advertises the real estate or real estate services. As long as your licensee's social media post has a link to their social media account profile page or another web page that contains those requirement element, the licensee will meet the requirements. So in other words, on your homepage, you have to have your name, your title, and the name of the brokerage. But you don't have to, on each post, have your name, your title, and the name of the brokerage. Any questions on that? You also are now allowed to register and use an alternative name for your advertising. So say your name is William and you go by Bill. So now you're allowed to register and use an alternative name for the advertising, a nickname, a middle name, or any name that the licensee commonly uses. So you have to make sure it's registered, however. Questions on that? So here's a summary for all that. Here's another thing that I think is very, very helpful. For terminating tenancies, what is allowed? That's a big one. You know, we're dealing with that right now when we're representing clients that have tenants in property and the buyer is requiring the seller to terminate that tenancy prior to closing. Or so what can we or can we not do? So here's what's allowed here. And when people are asking me, what's that again about the 90 days? What is again? I'm pulling the information directly here from the Oregon Realtors just because it's the best source. So what can you do with terminations? No cause termination is allowed within the first year without any issue. But if you have occupancy more than a year, it's not allowed any longer. If you have a qualifying landlord reason for termination, you can do it after a year. But the qualified landlord reason for termination are such things as the fact that the buyer for the property is going to be moving into the property, or the landlord's family, immediate family, or the landlord themselves are going to be moving into the property, or there's need for major renovations within the property. Those are the sort of things that are allowed for the landlord to terminate after occupancy by that tenant has been there for more than a year. Now, non-payment of emergency rent periods, fees, and charges, you can't. I believe we're still under some of those eviction scenarios. Those the COVID eviction moratorium, I think, is still in place. Non-payment of current rents, fees, charges, and a tenant cause other than non-payment. Yes. So termination prohibited through September 30th of 2022 if tenant has provided notification to landlord of an application for emergency rental assistance by June 30th, 2022. So again, great places to go for questions on this. Also for tenants, another great source, as we talked about, was Multifamily Northwest. They are like the recognized best source for tenant stuff within the state. Questions on this stuff here?
Linnea, I have a question.
Yeah, Danielle?
I've got a listing that came back on the market, and the seller had provided 90-day notice to the month-to-month tenants that have been there, for over 10 years. The question is, do we need to give 90-day notice again? And I've come up with several different answers, and I apparently it's a real gray area. Can you speak to that a little bit?
Yeah, I have seen that here in this. Let's see, where is it? I've seen it written here in Oregon Realtors that yes, you have to start the 90 days over again. I've seen it. I will find it, Danielle, and send it to you.
I hear it's gray area. There's no case study, so we're going to err on the side of caution and give 90-day notice again, and that's what I'm telling all the showings going forward. But I just maybe, yeah, I'd love your take on it and more.
Yeah, there are. Yeah, I will. These are some of the documentations in here. I will find that, Danielle, and send it to you. But that's something I read recently. I'll just have to find the actual thing. Yeah, and I think erring on the side of caution is always good. Also, finding if your landlord really is trying to be very careful about it. I was pleased to see that email that went through the office yesterday about hiring an attorney to serve the eviction. There are attorneys out there who are really experts on this. There's other ones who are not. And finding one who really recognizes and knows and is up on the current laws, because the laws keep changing. And every time you turn around, there's a new mandate from the governor or a new law that's in place. So we have to have an attorney who's really up on what the process is as of today, not what the process was a year ago or 2 years ago. It's important that we're dealing with people who really know what they're doing here, just to make sure all parties are protected. Yeah, good question on that.
Linnea, can you add to our subs list attorneys that are experienced in that? That would be good to have in our book.
I will ask. There are a number of good local real estate attorneys that people ask me about, and I do pass that on. But for ones who are really experts, in this. There are a couple from the state that I really would recommend. So I will get those names to you. Thank you, Diane. That's a very good question for
I
eviction.
appreciate it, because I've used almost every attorney in town, but I've never had to evict, so I don't know who would have that experience. So that would be good. Thank you.
Yeah, I will. Thanks. Yeah, any other questions on this? There's even some guidance here on multiple offer scenarios, how to handle that. These are things that we've talked about before, about producing tips in a spreadsheet, people who offer with escalation clauses. Now, recognize with an escalation clause, your seller doesn't have to accept an escalation clause. Your seller can counter and say, sales price to be whatever is the top end of that escalation clause. That's one of the things that you risk when you're representing a buyer and you're producing an escalation clause, that the seller could come back and say, and we've had agents do this within our brokerage, say escalation clause does not apply to this transaction, sales price to be whatever it is, and then the buyer accepts. So, or we can have sometimes sellers say, well, I don't want I will honor the escalation clause. We've had it go both directions, so understand that. Also, remember, also in a multiple offer situation, that with the seller's permission, you can disclose the existence of other offers. If an agent asks you, you don't advertise it, but if an agent comes to you and says, when you're representing a seller and you have multiple offers, has your seller given you the authority to disclose what the terms are of the other offers? And if the seller has, you can say, yes, they have. These are the terms. This is the top price. This is, it's cash, whatever. Because recognize when you're representing a seller, your duty is to give the seller as many offers at best terms and price that work for them. And so if you've had that conversation when you take the listing and you get it in writing that, yeah, they've given you authority to disclose this information, then there you go, you can do it, but only if the other agents ask. And the same thing is true when you're representing a buyer and you know there's going to be multiple offers. You should ask the listing agent, has your seller given you authority to disclose the terms and condition and terms of the other offers? And if they say yes, then you say, can you give that to me, please, so I can better represent my buyer? But again, sometimes people don't know about this and they don't ask. And if you're representing I used to hear people come back and say, well, I can't do that. I have to be fair to all parties. Well, the party you're representing is actually, and yes, that's true in a real estate transaction, but also recognize that our code of ethics does allow us to do this only if our client has given us the authority to do it. Questions on that?
I have a question. So if they do give permission, is there something they can put in writing?
Yeah, I actually do have an addendum we put together. I'll send that out to you guys too, the addendum. So I got to write that, the advisories on the information on rentals, attorneys. Yeah, I'm writing my list now. Yeah. And yes, there's in a document that you can do at the point of time you take a listing. It's something we produced in office because there's not an official listing document to that effect. We produced it in office after I attended a webinar about it. And I think it's a pretty good document. It's just a way of getting your client, your listing, your seller to give you the authority to disclose this information. Any other questions? Okay. Okay, I think I've covered most everything here that I wanted today. I'd like to open it up now to any haves and wants, and also just to acknowledge Catherine Bedford as a new broker within our company. So Catherine, I know, is on this call or on this go-to meeting today. So welcome, Catherine. I'm super excited to have you with us. And you have something you want to say?
Yes, thank you. I'm so happy to be here.
Wonderful. So we now have two Catherines with a C. So Kate Cushman, of course she goes by Kate, but her name is Catherine, and now Catherine Bedford. And of course, now we have Catherine Miller, and that's Catherine with a K. Any haves or wants by anybody?
Well, and I was just going to say there's 7 other Catherines that I've reached out to trying to recruit to our office just to corner the market on Catherines.
Well, I love Catherine. In fact, if I had had another little girl, I would have called her Catherine. But my husband said no more than 3.
Welcome, Catherine. I got to know Catherine on a personal level recently, and she will be a delightful, professional, and super kind, joyful member to our brokerage. Welcome.
Thanks. Thanks, Danielle. That's great. Any other haves or wants anything from people here today? I know Holly has a new listing hitting the market today. It's on Fargo. I know she was on the call earlier, and I think she's off right now, but I know we got photos done. Fargo, I believe it's 789. Mount Vista. Actually, it's Mount Vista. Thank you, Mount Vista. It's active now on MLS, Emily's telling me. So new listing there. I know Kate has a new one. It's incoming soon right now. Northeast Bend on Patriot, I believe. I know Brad's taking the photos of that right now. Any other?
I have a have coming up. 84 Northwest Portland. Walkable to downtown, walkable to the river, to the First Street Rapids. It's brand new construction, about 2,100 square feet, main level master, 2-car garage, 3-bedroom, 2.5 bath plus an office, and an ADU over the garage. That's a 1-bed, 1-bath ADU. Will be about $1 million.
Information on that?
I'm sorry?
Can you please send me the information on that?
I can, yes.
Yeah, that'd be great.
And yeah, and if you don't get it from me soon, please remind me, because as soon as I stop talking, I'll probably forget you asked. So we'll be somewhere at 1.5 to 1.6 million, but it is absolutely a stunning house.
Is the ADU permitted, Eric?
Yes.
Awesome. Wow, you checked all the boxes.
Yeah. Yep.
Awesome.
I have 2
Danielle?
buyer needs.
Oh, yeah, Diane, 2 buyer needs.
Congratulations, Eric. That's a great one, a great neighborhood too.
Thank you.
So the 2 buyer needs, the first one is a couple wanting investment property, duplexes or multifamily up to $1 million, and would prefer 4 units to 6 units, and rents well, of course. And then the other is a couple wanting land or land with a home on it with either river or cascade views. They like north of Bend, like Lower Bridge, Terrebonne, Tumalo, that area. They just want privacy, and they can go to a mill 5. Thanks.
Oh, wow. Yeah. Well, it looks like some good needs. It's amazing to think. Yeah.
I've got a buyer looking either Black Butte Ranch or Sun River up to $1.1 million. When I run that search in Sun River, there's 2 houses to look at and none in Black Butte Ranch. So if you know of anything on the horizon, please let me know.
Okay. All right. Any other house or wants? Yeah,
I have a question for you. Apparently there's a condo coming up in the Franklin building. I've got a client who's been chomping at the bit for the Franklin building, and her lender is saying that due to the percentage of commercial properties in there, that it's not financeable. I did find somebody in Portland, but if anyone knows anything about this, I'm looking for education on that. Have you heard about those condos not being financeable?
Well, my understanding of a lot of things are it's a secondary market, like for Fannie, Freddie, that if there's a higher percentage of commercial or things that are rented out, they can't sell it on the secondary market. That's not to say that portfolio lending would not work. So you may want to check with some of the places like On Point or some of the other service companies, maybe even some of the bigger banks that may do some portfolio lending too.
I
Oh,
found
there
somebody
you go.
in Portland, but
Now, Eric just posted here on the chat. He said here, Lisa Haas, Summit Funding for condo financing.
perfect. Thank you, Eric.
Yep.
Great. Anything else, guys? All right. If not, good meeting, people. And I will be sending things off. You guys have given me some homework to work on. So I will get that information out to you. And it's good stuff. So thank you so much. And we'll talk to you soon. Thanks, guys.
Have a great day,